Hello everyone, I'm Himanshi Hans. In today's video, we will be discussing the recent judgment delivered in the case of Anjum Kadari and another versus Union of India and others, which was delivered on 5th of November 2024, wherein the Hon'ble Supreme Court set aside the judgment of the High Court of Judicature at Allahabad dated 22nd March 2024, which held the Uttar Pradesh Board of Madarsa Education Act 2004 to be unconstitutional on the ground that it violates the principle of secularism and Articles 14 and 21A of the Constitution. Let us first discuss the proceedings before the High Court and the impugned judgment. In 2019, a writ petition was instituted before the High Court by a part-time assistant teacher in one of the Madarsas. He sought regularization of his services and salary at par with regular teachers. By an order dated 23rd October 2019, a single judge of the High Court observed that certain questions related to the wires of the Madarsa Act arose for consideration, which warranted consideration by a larger bench. Other similar writ petitions were also referred to a larger bench. Then another writ petition was filed challenging the wires of the Madarsa Act on the ground that it violates the principle of secularism and Articles 14, 15 and 21A of the Constitution. A challenge was also mounted on the constitutionality of Section 1, 5 of the Right of Children to Free and Compulsory Education Act 2009, which states that the Act does not apply to Madarsas. All these petitions were tagged together and placed before the division bench of the High Court. By a judgment dated 22nd March 2024, the High Court held that the Madarsa Act violates the principle of secularism and Articles 14, 21 and 21A of the Constitution of India and is ultra vires Section 22 of the UGC Act, which provides for right to confer degrees. According to the High Court, the object and purpose of the Madarsa Act itself violated the principle of secularism, and thus it is not possible to segregate or save any portion of the legislation. The High Court held that the Madarsa Act in its entirety was unconstitutional and directed that the state government should take steps to accommodate all students studying in the Madarsas in regular schools recognized under the Primary Education Board and the High School and Intermediate Education Board of the state of Uttar Pradesh. The state government was also directed to establish sufficient number of additional seats and new schools if required for this purpose, and to ensure that no child between the ages of 6 and 14 is left without admission in a duly recognized institution. Now, coming to the case of Anjum Kadari versus Union of India. Let us first come to the submissions. The petitioners challenged the impugned judgment on the grounds that, first, the state legislature is empowered under Article 246 of the Constitution of India, read with entry 25 of List 3 of the 7th Schedule, to enact legislation to regulate Madarsa education. The Madarsa Act principally deals with the regulation of Madarsas concerning curriculum, instruction, standard of education, conduct of examination and qualifications for teaching. The enactment of laws for regulating secular activities of minority institutions or prescribing standards of education is consistent with Articles 25 to 30. Secondly, they relied on the judgment of S.R. Bomai versus Union of India, wherein it was held that secularism is a positive concept of equal treatment of all religions. Articles 25 to 30 secure the rights of religious and linguistic minorities, including their right to establish and administer educational institutions. By recognizing and regulating the Madarsa education, the state legislature is taking positive action to safeguard the educational rights of the minorities. Thirdly, Article 28 prohibits religious instructions in educational institutions wholly maintained out of state funds. Madarsa impart education based on modern curriculum such as mathematics, social sciences, and science. Additionally, madrasas impart education about religion and not religious instructions. Article 28 does not bar the state from funding schools providing religious education. Fourthly, Article 21A recognizes the fundamental right of children between the ages of 6 to 14 to free and compulsory education. Section 1(5) of the Right to Education Act excludes madrasas from the purview of the legislation. So, the law enacted by the state in pursuance of Article 21A cannot violate the fundamental rights of minorities to establish and administer educational institutions. Lastly, they said that striking down the Madarsa Act will create a legislative vacuum and result in the deregulation of madrasas. This will affect the future of more than 12 lakh students studying across the madrasas in Uttar Pradesh. Further, the direction of the High Court to relocate students studying in madrasas to regular schools will effectively shut down all madrasas in the state and result in violation of Article 30 of the Constitution. Let us now come to the submissions of the respondents. Firstly, the Act does not make any provisions to impart secular subjects as part of the curriculum and is a measure undertaken by the state to recognize and regulate religious instruction traceable to a particular community. Secondly, Article 28 prohibits institutions which receive funds from the state from imparting religious instruction. Thus, as a corollary, the state cannot seek to regulate and thereby recognize religious instruction. Thirdly, the preamble which specifies that India is a secular republic, Article 21A, Article 25, Article 28, Article 30 and Article 41 all point to the pervasive principle of secularism underlying the Constitution. This principle militates against the state regulating religious instruction. Fourthly, the striking down of the Act would only discontinue the functioning of the board and the consequent state recognition of religious instruction. The education provided in the madrasas and their existence would continue to be protected by Article 30. Fifthly, the word education in entry 25 list 3 of the 7th schedule must be construed to mean secular education and cannot include religious instruction. Thus, the state legislature only has the competence to enact a law that regulates educational institutions but no power to recognize and regulate religious instruction. Lastly, entry 25 list 3 is subject to entry 66 list 1 which pertains to higher education and standards. The Parliament has enacted the UGC Act under entry 66 list 1. Section 22 of the UGC Act provides that no degrees can be conferred by any institution other than the institutions defined under the UGC Act. Thus, the provisions of the Madarsa Act which regulate higher education at the undergraduate, graduate and grant the board power to grant equivalent degrees are beyond the legislative competence of the state legislature. Let us now discuss some other important submissions which were made by the interveners. Firstly, the Madarsa Act deprives students enrolled in such institutions of the benefits of mainstream, holistic, secular education, thereby violating Articles 21 and 21A. Secondly, the Madarsa Act divests students of equal opportunity in relation to future employment opportunities as per Articles 14, 15 and 16, and the right to practice any profession, occupation, trade or business of their choice as per Article 19(1)(g). It creates two classes of children, the first who receive secular mainstream education and second who receive religious instruction, which prohibits them from even attempting to adopt professions which are easily available for the former class. This deprivation of choice also violates the constitutional value of dignity and deprives students of liberty of thought and expression protected under Article 19. Thirdly, the Madarsa Act violates the constitutional value of fraternity as the dissemination of Madarsa education creates intellectual and outlook barriers which prevent students from integrating into a pluralistic society. Fourth, the definition of Madarsa education in section 2H indicates that the focus on other branches of learning is only tertiary. The focus of the statute and the competence of the board is restricted to religious instruction. Fifthly, the board is disproportionately populated by persons whose competence is in the field of religious instruction. As decisions of the board are taken by a majority of members present and voting, the views of the non-secular members would prevail and the curriculum is likely to be skewed in favor of religious education. The functions of the board delineated in section 9 also indicate disproportionate weightage to religious instruction. Lastly, the qualifications for teachers in the Madarsas laid down in the regulations are not adequate to ensure quality education. The qualifications are rooted in the same Madarsa echo chamber and the minimum requirements for teaching in regular education institutions are not prescribed. Now, let us come to what was held by the court in this judgment. In this judgment, the Hon'ble Supreme Court delved into the concept of secularism. The preamble to the Constitution enshrines the declaration to constitute India into a sovereign, socialist, secular, democratic republic. Articles 14, 15 and 16 mandate the state to treat all people equally irrespective of their religion, faith or belief. Secularism is one of the facets of the right to equality. Articles 25 to 30 contain the other facet of secularism, that is the practice of religious tolerance by the state. Secularism is embodied in the constitutional scheme, particularly Part 3, in the landmark judgment of Kesavanand Bharti versus State of Kerala. The Supreme Court held that Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. It was held that the power of the Parliament to amend the Constitution cannot have the effect of destroying or abrogating the basic structure or framework of the Constitution. In the judgment of S.R. Bommai versus Union of India, a 9-judge bench of the Supreme Court held that secularism is a basic feature of the Constitution. Now, the issue in the present case was whether the basic structure doctrine can be applied to invalidate ordinary legislation. The Constitution imposes certain limitations on the legislative powers of the Parliament and state legislatures. Article 13(2) provides that the state shall not make any law that takes away or abridges the rights conferred by Part 3. Statutes enacted by the state legislatures must be consistent with the fundamental rights enumerated under Part 3 of the Constitution. In the judgment of Kuldeep Nayyar versus Union of India, a constitutional bench of the Supreme Court held that the ordinary legislation cannot be challenged for the violation of the basic structure of the Constitution. It was concluded by the court that a statute can be struck down only for the violation of Part 3 or any other provision of the Constitution or for being without legislative competence. The constitutional validity of a statute cannot be challenged for the violation of the basic structure of the Constitution. The reason is that concepts such as democracy, federalism, and secularism are undefined concepts. Allowing courts to strike down legislation for violation of such concepts will introduce an element of uncertainty in our constitutional adjudication. Hence, in a challenge to the validity of a statute for violation of the principle of secularism, it must be shown that the statute violates provisions of the Constitution pertaining to secularism. The right to administer minority educational institutions encompasses: first, the right to constitute the managing or governing body; second, the right to appoint teachers; third, the right to admit students subject to reasonable regulations; and fourth, the right to use property and assets for the benefit of the institution. In the judgment of In Re Kerala Education Bill, the Hon'ble Supreme Court classified minority educational institutions into three categories. Firstly, those which do not seek either aid or recognition from the state; secondly, those which want aid; and third, those which want only recognition but not aid. The state has an interest in ensuring that minority educational institutions provide standards of education similar to other educational institutions. The state can enact regulatory measures to promote efficiency and excellence of educational standards. The statement of objects and reasons of the Madarsa Act indicates that it is enacted to remove difficulties in running madrasas and improve the merit of students studying in madrasas by making available to them facilities of study of the requisite standard. The legislative scheme of the Madarsa Act suggests that it has been enacted to regulate the standard of education in madrasas recognized by the board for imparting madrasa education. The Supreme Court held that the High Court erred in holding that education provided under the 2004 Act is violative of Article 21A because the RTE Act, which facilitates the fulfillment of the fundamental right under Article 21A, contains a specific provision by which it does not apply to minority educational institution. Secondly, the right of a religious minority to establish and administer madrasas to impart both religious and secular education is protected by Article 30. And thirdly, the board and the state government have sufficient regulatory powers to prescribe and regulate standard of education for the madrasas. Article 31 guarantees the right to establish and administer educational institutions of their choice to religious and linguistic minorities. However, the state has an interest in ensuring that the minority educational institutions impart secular education along with religious education or instruction. Let us now discuss the legislative competence of the state. The distribution of legislative powers is contained in Part 11 of the Constitution. Article 246, Clause 2 confers the exclusive power on Parliament to make laws with respect to any of the matters enumerated in List 1, the Union List of the 7th Schedule. Entry 25, List 3 reads as follows: education, including technical education, medical education, and universities, subject to the provisions of entries 63, 64, 65, and 66 of List 1. Vocational and technical training of labor. The provisions of the Madarsa Act seek to regulate madrasas. These are educational institutions run by a religious minority. There is a distinction between religious instruction and religious education. While the madrasas do impart religious instruction, their primary aim is education. Legislative entries must be given their widest meaning, and their ambit also extends to ancillary subjects which may be comprehended within the entry. The mere fact that the education which is sought to be regulated includes some religious teachings or instruction does not automatically push the legislation outside the legislative competence of the state. Merely because an educational institution is run by a minority or even a majority community and professes some of its teachings does not mean that the teachings in such institutions fall outside the ambit of the term education. The court held that there is no jurisprudential basis to read entry 25 list 3 to be limited to only education that is devoid of any religious teaching or instruction, and to contend that the Madarsa Act in its entirety, which seeks to regulate the functioning of madrasas in Uttar Pradesh, is outside the competence of the state legislature, is invalid. Hence, the challenge on the ground of legislative competence was not considered to be relevant. Next, entry 25 of list 3 has been made subject to certain entries in list 1. One of these entries is entry 66 of list 1, which reads as follows: coordination and determination of standards in institutions for higher education or research and scientific and technical institutions. The Madarsa Act, to the extent to which it seeks to regulate higher education, including the degrees of Fazil and Kamil, is beyond the legislative competence of the state legislature, since it conflicts with Section 22 of the UGC Act. Entry 25 of List 3, pursuant to which the Madarsa Act has been enacted, has been expressly made subject to entry 66 of List 1. The UGC Act governs the standards for higher education, and a state legislation cannot seek to regulate higher education in contravention of the provisions of the UGC Act. Let us now come to the conclusion what was held by the court. Firstly, the Madarsa Act regulates the standard of education in Madarsas recognized by the board for imparting Madarsa education. Secondly, the Madarsa Act is consistent with the positive obligation of the state to ensure that students studying in recognized Madarsas attain a level of competency which allow them to effectively participate in society and earn a living. Thirdly, Article 21A and the Right to Education Act have to be read consistently with the right of religious and linguistic minorities to establish and administer educational institutions of their choice. The board, with the approval of the state government, can enact regulations to ensure that the religious minority institutions impart secular education of a requisite standard without destroying their minority character. Lastly, the court held the Madarsa Act to be within the legislative competence of the state legislature and traceable to entry 25 of list 3. However, the provisions of the Madarsa Act, which seek to regulate higher education degrees such as Fazil and Kamil, were declared to be unconstitutional as they were found to be in conflict with the UGC Act, which has been enacted under entry 66 of list 1. So that was it for the discussion on this judgment. I hope you understood the judgment and found the discussion to be fruitful. Thank you for watching. See you next time. Bye bye.